Bill remains on call. We have Senator Wachowski. You are here with item 4, SB 1007, and item 9, SB 1241. Take them in any order.
Let's start off with SB 1007.
All right, item 4.
What? Oh, yeah, let's do 1241. That was the game plan. So,
all right, item 9.
Continuing your morning's conversation on arbitration bills, this SB 1241 focuses on two of the worst kind of clauses that appear in consumer or employment contracts. One is the choice of venue that require a consumer to go to arbitration to a court in an entirely different state, and the other is choice of law, the clauses that intentionally pick a state law governs what state law governs the arbitration, and thus deciding the rules normally to disadvantage. I'd like to remark that the staff report prepared by Mr. Dang was exceptional, I thought, in this, in the clarity and the understanding of the issue. You know, a California consumer should never have to be forced to travel to a different state to exercise her rights, to litigate or resolve an arbitration claim. If you're selling goods or services in California or employing Californians, you should not be able to force all dispute resolutions to take place in Delaware or Florida. Just the cost of travel alone prevents California consumers who have been harmed by an illegal practice from seeking compensation. This is especially true when the controversy is so small, and it's a very large business, and they actually have an opportunity to take advantage of our consumers. The only reason a business that wrote the contract would want the law in some other state to apply is to the disadvantage of the consumer, because that state law's consumer protections are weaker than California. We hope that SB 1241 ensures that a California consumer who purchases goods or services here in California has her dispute resolved in California using California law. And I have with me Tara Zumar, a former Rework employee, and Cliff Pavlevsky with the California Employment Lawyers.
Thank you. First witness in support.
This bill is not just an arbitration bill. It applies to arbitration and litigation. It goes to the very integrity of what you do here. You pass laws because they're necessary. Your discrimination laws, your whistleblower laws, your overtime laws, your health and safety laws, and out-of-state companies or even in-state companies who don't like being regulated by your laws require that you waive not only your right to that law, but require that you litigate them in a distant and expensive location. And this is nothing more than claim suppression. It goes to the very heart of California public policy and what you do. Ms. Zoomer will tell you about her own personal story trying to collect her wages, but I can tell you that I've had to try cases for commission theft in Seattle. I've had cases sent to Florida for California employees. If what you do here means anything to you and to the people of California, please make sure that the people of California get the benefit of the laws that you pass. Thank you very much.
Thank you. Next witness, please.
Hello, my name is Tara Zoomer, and I'm here today because the government is the only institution citizens have that is big enough and powerful enough to protect their rights. And until this experience, I never knew that companies could take away people's rights through forced arbitration. In March of 2015, I was hired by WeWork as an associate community manager for a salary of $42,000 a year, or $82 per day. And although the title was vague and the salary was low, I was excited to be part of a growing startup and eagerly signed my offer letter. The office leasing startup, valued at $17 billion, offers members free beer, amenities, and events on every floor. At the time, I didn't realize their rapid growth was due to the free exploited labor of its young employees. While I believe the mission of the company, I noticed myself and my coworkers were working an extra 10 to 30 hours a week, doing mostly menial labor tasks like retrieving mail and changing kegs. Early on, I reported the issues of work-related stress and understaffing, and I was met with a common answer in Silicon Valley. We're a startup. We're figuring these things out. Barely living paycheck to paycheck, I began to build a case for our misclassification as salary-exempt workers. I hoped that we would have a collective chance to fight for fair wages and working conditions. When my manager found out about my case, she told me to stop talking to other employees about their rights because their path is their path, and I should just let everyone discover it on their own. She said that my discussions about wages were negative to the workplace and asked if I wanted to resign. A few weeks later, managers from HR and legal surprised each office, requiring all employees sign new paperwork. A conference room was set up with managers, stacks of paper, an empty chair, and a pen. Employees were then called in one at a time. When it was my turn, a stack of over 50 pages was placed in front of me, including a new employee handbook, a non-disclosure agreement, and a 7-page arbitration agreement they titled an Employee Dispute Resolution Program. I was told that these documents were standard, but they were not. I thanked them and asked them for time to read the documents before signing, and as I feared, the new pages included an arbitration agreement which waived our rights to a trial by jury and class action claims. In one day, I watched a company take away people's rights to fight as a collective unit. When I asked what would happen if I refused to sign, I was told that my continued employment was sufficient to constitute acceptance of the new agreements. I asked myself why the company even asked for our signatures if we really had no choice to begin with. I refused to resign and I refused to consent to the new agreements because as a citizen, I never want to give up access to my judicial system. On Monday morning, I was fired for refusing to comply. My case was filed on Christmas Eve, and although I successfully refused being forced into an abusive arbitration agreement, the single sentence in my original offer letter mentioning arbitration was upheld in a court of New York. My case should have been tried in the court of law it belongs in the state I actually live and not 3,000 miles away, by judges not paid for by my former employers and by a jury of my peers. From the beginning of my employment, I never had a choice. I'm here today as proof of the true nature and danger of these agreements, and I'm fortunate to be educated and have English as my first language, but many in our country are not. My story is one of many, and I urge you to support this bill to reverse the damage being done to citizens through the privatization of our court system. Companies should never have the ability to take away the rights of citizens. Thank you.
Thank you. Next witness, please.
Yes, good morning, Mr. Chair and committee members. My name is Elise Sanguinetti, and I'm here in support of SB 1241, and I urge your aye vote.
Thank you. Anyone else in support?
Good morning. Aaron Lewis for the Consumer Federation of California in support. Thank you.
Thank you. Anyone else in support? Seeing none? Opposition?
That's 4, and that's enough.
Good morning, Mr. Chair and committee members. Jennifer Barrera on behalf of the California Chamber of Commerce, and we are opposed to SB 1241. From our perspective, the bill is unnecessary to the extent that the courts already have judicial discretion to weigh the individual facts of each particular case and determine whether or not these clauses, such as a choice of law or choice of forum clause, should be upheld under the particular circumstances. For example, the courts can weigh the factors as to how the contract was entered into, where the witnesses are, where the documents are, where the financial expenses would be for either party, and the burden that they would be under if they were required to travel to another forum. They can also look at both states and determine whether the choice of law in that particular state has a greater interest than the other forum where the employee or consumer particularly resides. And I've seen a lot of cases, well, California, not surprisingly, has said we have a stronger interest because we have stricter labor laws, we have stricter consumer protections here in California, and so therefore we have a stronger interest than other states in this country. So right now the courts have that judicial discretion to weigh all these factors and determine what the appropriate forum is and what the appropriate law is. When you put a one-size-fits-all kind of provision such as this into statute, it eliminates the court's discretion to determine whether or not California is the particular forum that should be the place where they litigate, whether California law is the appropriate law, or whether you should go to a different state or a different forum. I heard the proponents suggest multiple times that we're only protecting California consumers, we're only protecting California employees, but that's not actually accurate. The bill is applicable to anybody, regardless of whether they primarily reside here in California. So an employee who is only here in California for one one day can void their contract even though they live and primarily work in another state. A consumer who is only here for one day can void their contract even though they live and primarily reside in another state. So this bill is not just limited to employees and consumers that actually reside and work here in California, but is applicable to anybody who comes in here for only one day. We appreciate the author's amendment that excludes those who are legally represented by counsel through the negotiation of their contracts. But this is also applicable to highly compensated executives who certainly have the ability to negotiate their own contracts and agree to terms of those contracts, including a choice of law and choice of venue provision. It also deals with professional athletes who are only California for one particular day and yet could forum shop and use California to file their lawsuit and void contracts provisions that they've agreed to. So again, this one-size-fits-all doesn't take into consideration the multiple factors that go into play with regards to where the appropriate forum is and what the appropriate law should be applied to that particular case. And for those reasons, we are opposed.
Thank you.
Mr. Chair, members, Chris McKaylee on behalf of the Civil Justice Association of California. And first, I wanted to thank the author and his staff for continued discussions on this and other arbitration measures. But we do, as Ms. Barrera indicated, fundamentally have a difference of opinion. If you look back at some of the cases that are even cited in your analysis, in 2001, the America Online case, a forum selection clause wasn't enforced because the claims would have been litigated in Virginia. Similarly, in 2015 case where a forum clause was not enforced because there was an insufficient showing that an employee's rights would be protected by Texas courts. And I would bring to your attention AB 267 from 2011 that this governor vetoed, where he indicated that current law prohibits California employees from being subjected to laws or forms that substantially diminish their rights under our laws, and I have not seen convincing evidence that these protections are insufficient to protect employees in California. We would submit respectfully that there has been no showing, no convincing evidence, even since that veto in 2011, and while there are remarks that this bill says voidable, I would also point out that it specifically says that these types of clauses are prohibited as a condition of employment, so prohibits them outright, which we think is very consistent with AB 267, and that was vetoed by Governor Brown in 2011. Thank you.
No.
Thank you. Next witness.
Morning, Mr. Chair. Member Alex Alanis with the California Bankers Association. We're just here to talk about the civils code section on the bill, Section 1. We think that, well, we represent multi-state institutions that do business in all 50 states and international. We don't think a patchwork approach to this is helpful. We are governed under the National Bank Act, which may be preempting this statute if you attempt to use it to dispute pricing on consumer contracts, credit cards, or other consumer contracts for a bank. We think arbitration is an efficient method in order to solve disputes between the parties, such as dispute resolution, which is already protected under federal law. Consumers have numerous protections under federal law with respect to financial institutions, such as the Fair Credit Reporting Act, the Fair Lending Act, the Card Act of 2009, also Dodd-Frank, which also created the Consumer Financial Protection Bureau, which does a pretty good job, I think, for most folks, for consumers, protecting them and providing enough guidance on how to dispute issues relating to financial products. So with that, we are opposed to the measure.
Thank you. Anyone else in opposition? If you just give your name and your affiliation, please.
Nicole Rice, California Manufacturers and Technology Association, also opposed.
Thank you.
Mr. Chair and members, Terry Thomas on behalf of the Motion Picture Association of America in opposition.
Thank you. Any other opposition? Seeing none, I'll bring it back to the committee. Questions, comments? Mr. Wagner.
Thank you, Mr. Chairman. A couple of things I frankly like in the bill, but there are a few things that just really give me problems. And one is you say the bill says the employee can't be forced to travel out of state. I can understand that, but it goes beyond that. It also says, deprive the consumer of protections of California law with regard to controversies arising in California. That sounds nice, but is a wholesale substitution of state law for any other state's law, which is obviously what you're trying to do, but flies in the face of generations of American law that respects choice of law provisions, flies in the face of, perhaps doesn't oppose it, but certainly stands in contrast to the full faith and credit clause of the Constitution. And I see your witness shaking your head, and no, I don't think a challenge to full faith and credit would survive. But nevertheless, it is sort of intellectually going in the other direction. I have that problem with it. And then the other thing I have a problem with is that the provisions apply except when there's a lawyer on the employee's side to negotiate these terms, which strikes me as sort of a full employment act for lawyers. And second of all, a recognition that these provisions can be useful, can be in contracts as long as there's disclosure. Why not just a disclosure requirement and approve it? So for those reasons, I think your bill goes farther than I would be comfortable going.
I think you're addressing what my concern is the voluntariness of it. If somebody, the reason we have the attorney provision in there and we amended the bill was that we presume that if you want to voluntarily bind yourself to go to Rhode Island and apply Illinois law, and that's what, and you're getting some compensation from that, because again, we've got this sophisticated CEO mysteriously negotiating her own contract. Might happen, it's possible, but we assume that there's a level of sophistication and a level of voluntariness that in those cases, sure, you're bound by the contract. But normally, the 99% of the time, these are take it or leave it arbitration clauses. There's no the suggestion that that I get a cell phone and I'm bound to go to Delaware to dispute my $3.60 per month dispute is unreasonable, and we want to have that forum and that California law apply.
I agree with you. It's unreasonable to drag the consumer who buys a cell phone to Delaware. Mm-hmm. And if your bill only said that, I would agree with you. But I also think that the bill goes farther than that and says that you can't apply, you can't, as somebody in commerce in this country, have the certainty of the application of a particular set of laws and know that you abide by those laws. You've got the uncertainty of having to do 50 individual state laws. I mean, I think that's where you go too far. Mm-hmm. And again, the voluntariness, I know that's exactly what you're getting at with the lawyer provision, but I think that short of forcing the employee to hire a lawyer, you can still address the voluntariness. And so that's, as I say, that's why I have those concerns, Senator.
I'll let my witness respond.
Well, no,
further.
we're not. Yeah, if he has a question,
okay,
you can respond. But
okay.
I didn't hear a question in there.
Well, I mean, we're debating the extent of the voluntariness, I think, and the consumer protections. And the senator, I suspect, disagrees with me in the scope of his bill. If his witness would like to expand on that or explain to me where I'm wrong, I'd be happy to hear that explanation from the witness or the senator.
I mean, I thought some of the concerns, and it was brought up by the opposition, about the previous veto by the governor, and when the bill said it was simply void, and we hope that it's voidable. That if there are reasonable reasons why this should be enforced, this arbitration clause, then we hope that narrows the scope of the bill. I I think that there may just be a fundamental difference that we have in whether the value of the arbitration, use of arbitration. I think they're valuable. I just think that we need to, there's some abuses that are going on, and I want to see, or at least this legislation hopes, that we have a forum for our California consumers. Because remember, we're not, this suggestion that you're in California for one day, I just wholesalely disagree. This is designed for Californians signing contracts here in California, and that's the thrust of it.
And did you want to respond?
Yeah. In the employment context, every state has their own employment laws. There may be some federal statutes, but when you're talking about state by state, absolutely every employer has to conform to the laws of every single state. Our labor code is a model for the country. Our Supreme Court has said those rights are unwaivable. You can't have a situation where you pass critical labor laws and require out-of-state employers to have you forego them. It's a matter of states' rights. I'm surprised that this legislature, or even folks who are concerned about the rights of California to ensure that their laws get enforced and that their public policies get enforced and that their employees and citizens are protected against involuntary. When it says condition of employment, it means that you didn't really have a choice. California law, Labor Code 923, recognizes that individual workers, not consumers, but workers, don't have the ability to freely negotiate terms of labor. That's California public policy. That's federal public policy.
With all due respect, I apologize, and I know everybody hates that phrase. I was reading the section with respect to consumer protections, not employee. I know our labor laws aren't waivable. I get all that, but my concern was on the other side with respect to consumers. So, thank you.
Okay.
Mr. Gallagher.
Yeah, I think the issue is in just making it de facto voidable. I mean, I think the points that have been made are if there is present issues of undue influence, duress, if the contract is found to be unconscionable, we have those principles of law that allow us to void out certain provisions of a contract. But to just say any kind of provision that allows for choice of forum or choice of law is de facto voidable in the state of California, I think that's just way too broad. I mean, people do form contracts, and that's the whole basis of the freedom to contract, is that you spell out the terms of your deal, and then people are bound by that after they sign that contract, and they're bound, in what happens after that fact, right? Well, now you can say, well, hey, people, have to sign these as a condition of employment. Well, you don't have to work at that place either, right? You can work for other companies. You could decide to give your labor somewhere else, right? The issue comes in the sense of was there duress, was there undue influence? Are there other factors here that implicate that provision shouldn't be enforced in this context? Right? We already have that law available. That's available to people to make that argument. But to just say that these are de facto avoidable as a matter of public policy, even when those types of things might not have been present and someone voluntarily signed this contract or became a party to this, and now they're saying, well, I just don't want to be bound by it. Well, we signed a contract, right? So I just think it goes too broad to say that all of these provisions are going to be now avoidable in California when parties should be able to decide whether or not they want to have a choice of forum or a choice of law.
Okay, I don't know if you want
Senator, you respond to that. And I think that's what the senator's addressing in here. Making something voidable is very different than making it void.
Right.
And they're not de facto void, but they are voidable under the circumstances that have been described here. And I think that's the step that he's creating.
And we were hoping with the amendment on the attorney that the flavor of your statement that these are contracts that are negotiated, they're hard fought. Each of these provisions are understood, and there's two parties coming together. We're not trying to get into that business and second guess why somebody chose Montana law to apply. We're talking about the typical arbitration clause in contracts of adhesions where there is no negotiation. People sign up for that. The consumer this bill is focusing on, and the bulk of the people that are going to be affected by it are people that had no choice, and they're California consumers and California employees.
Right, but you're getting into contracts of adhesion, and you're getting into unconscionability. You're talking about unequal bargaining power. All of these things are factors to be considered when it comes to unconscionability as a legal defense, right, to a contract situation. So that's already the law. But what you're saying with this bill is, no, I want to say that these provisions in a contract are de facto voidable, which then actually puts the presumption not on the person who's trying to get rid of this, but on the other party. If you're the one saying that this provision should not apply to me, you should have to make the case on as to why that is, either through an unconscionability argument, undue influence, duress. I mean, there's all, mistake of fact, all these different things out there, right, that you could argue. Why is it instead the presumption's on the other party to say, no, this is not voidable, basically?
Because we believe California consumers deserve it. We believe that there are hundreds, if not thousands, of arbitrators here in California, and since arbitrators don't have to apply law anyway, we're trying to give them some guidance that for consumers and for the employees, on balance, it's better to have those folks in the arbitration rooms here in California deciding it. You don't automatically win if that provision says you got to go to Delaware. It just means you get your day in arbitration hearing here in California. That's go ahead.
Let me just
Well, I'm going to hold you off there unless there's a specific question. So, any other comments from members? All right, Senator, you may close.
I ask for an aye vote.
Thank you.
That's my close.
And we're still looking for a motion and a second. The motion be to pass.
The bill.
And two appropriations. The do pass two appropes. Call the roll, please.
Stone.
Aye.
Stone, aye. Wagner. No. Wagner, no. Alejo. Alejo, aye. Chow. Chu. Gallagher. No. Gallagher, no. Garcia. Aye. Garcia, aye. Holden. Meanshine. No. Meanshine, no. Ting.
That bill is on call. Senator, you also have item number 4, SB 1007.
And this matter, SB 1007, will simply affirm a party's right to have a certified shorthand reporter in an arbitration hearing. Having a reporter's transcript can be essential to a consumer obtaining justice when there's instances of misconduct, corruption, and fraud in the arbitration. Simply, SB 1007 will codify that a party in an arbitration has access to a court reporter to transcribe any proceeding. Make a transcript the official record of that arbitration, and provide consumers with the ability to petition for a court order to compel an arbitrator if their request is denied, and to stay the proceedings pending the court's determination of the petition. Recent amendments specify when a party can make the request for the reporter, either in a demand, a response, or an answer or a counterclaim related to the arbitration, or at a pre-hearing conference. So we don't want to hide the ball and then ask for a reporter at the end. It also provides for indigent consumers to be able to have a court reporter provided at the expense of the non-consumer party. Establishing a party's right to a court reporter will help ensure a fair and unbiased arbitration process. It's good for all parties. It's good for the legislature, good for the consumer, good for the people in the arbitration business. And I have Larry Doyle with the Conference of California Bar Associations in support.
So your first witness, please.
Larry Doyle on behalf of the Conference of California Bar Associations. With the sponsor of the bill, like many of the bills, most of the bills come out of the conference, comes out of the experience of the lawyers in the conference who, in this case, we're seeking to have a court reporter in an arbitration to ensure that there is a record, because if things go bad, if you don't have a record at the end, there's absolutely nothing that can be done. So they were very appalled to find that the arbitrator said, no, there is no right, you can't have it. So we're trying to establish that this is indeed a right. To have a court reporter present in this. The major arbitration associations do have rules which, in one case, pretty much clearly say that there's a right, and the other case is kind of implies that there's a right. We want to make it sure that this is in the law. Senator Wachowski has explained the amendments that we have taken to ensure that this right does not impede the process, does not stand in the way, but it only makes sure that at the end of the day, if there's a need to appeal, that there is a record upon which that appeal can be based. And we think that it's good public policy, and hope you will support it.
Thank you. We do have a motion and a second. Other witnesses, please. Anyone else in support? Seeing none, is there any opposition?
Yes. My name is John Warrenloff. I'm an attorney in Walnut Creek, and I've been doing arbitrations for about 40 years and have done 1,000 of them. Former chair of the State ADR Committee, presently the president of CDRC, but I appear here as an individual. There's one small flaw with the bill, and that has to do with depositions. It's fine to want to have a record so an award can be reviewed to see if it should be vacated or not. But you don't need to include depositions. A deposition, by definition, is testimony that is taken outside of the arbitration and recorded by a court reporter. There is a record. Now, the other thing about the deposition issue here in this bill is that it says if you're an indigent consumer, you don't have to pay for the transcript for the deposition. And what I don't understand is, why is that in there? If you're in court and you're indigent and you get a fee waiver, your fees can be waived. You can file a supplemental application and get jury fees waived. But there is no right in civil court, not arbitration, to have a deposition given to you at no charge. So it seems to me that I don't oppose the bill. I mean, in the 1,000 arbitrations I've been involved in, I've never denied an opportunity to allow someone to have a transcript. And most of the arbitrations that I do are pursuant to American Arbitration Association, and they specifically have a rule governing transcripts. But I think that there is a flaw in here when you extend it to depositions, which already, by their definition, have a transcript. Thank you.
Thank you. Any other opposition or concerns with the bill?
One other thing I would say, just on the stay, I think you ought to think about making that stay automatic. It says that you have a right to make the stay part of your motion for an order allowing you to have a transcript. In most law and motion departments now, you're looking at perhaps around 3 months before you have a hearing on the motion. I think that you ought, if you're going to do it, you ought to do it like in the anti-SLAPP motions, that when you file the anti-SLAPP motion, there is an automatic stay that goes into effect upon the filing of the motion. And that would make this bill more effective, and it would also eliminate scheduling issues, because the arbitration may occur before your motion is ever heard.
Thank you. Thank you, sir. Although I would be concerned that an automatic stay would trigger a preemption problem under the Arbitration Act. But any other witnesses in opposition? All right, seeing none, I'll bring it back to the committee. Senator, perhaps you can address those concerns. I'm sorry, Mr. Wagner.
Well, no, let the senator address those concerns, and then I'll have a question or two.
Okay.
On the automatic stay, I guess I'll let my witness explain.
Well, the automatic stay, the reason we didn't put in the automatic stay is because of the concern expressed by the chair that this may be a preemption issue, and also because the courts, have not, though they have not taken a position on this, are rather sensitive to anything that increases their the amount of time and effort that they're going to have to expend on these issues. We are hoping. We actually like the idea of the automatic stay, and if that's a pleasure of the committee, we'd be happy to accept it, or to accept it with whatever conditions are necessary to make sure that, to the extent not superseded by or preempted by federal law, it would be required. We're hoping, frankly, that because we have established this as a right, and because there's a tendency in that direction, that there will be very few arbitrators who would in future decline a request to have a court reporter present and that therefore this thing will become self-effectuating without the need to go to the courts to take care of this issue.
Okay, thank you. Mr. Wagner?
Okay, I think that answers that question because, yeah, it'll be self-effectuating.
Yeah.
So I'm not too worried about that. I am worried, though, about a couple of other things in here. Number one, the transcript shall be the official record. First of all, we know how difficult it is to overturn arbitration awards in the first place. It's really hard to see too many times when the transcript will actually be an issue. But I do have a problem with the idea that this would in some way be an official record, maybe a record of a court proceeding, sort of like when you appeal, you've got the record from down below, especially when it's paid for by one of the parties. And we know that the court reporters, when they're getting paid by one party, are going to make sure that that one party's testimony is captured when there's, for example, overlapping communication. Just like in courts, we know when you're talking at the same time as the judge who the court reporter is going to be listening to and transcribing. So to make it the official record and to give it some additional weight, I don't know that makes sense. I don't know entirely how that plays out. And I also would agree with the witness entirely about the deposition. I don't understand why it has to be in there because by definition you've got a transcript in a deposition. So if you could address those two issues, I would be appreciative.
I think in the limited number of depositions that I've participated in, after they've been transcribed, both sides have an opportunity to go over to determine the correctness of them. So we're sort of stuck with that, whether the judge is talking or the witness is talking, and whatever gets transcribed, we have an opportunity to correct it so that we have the best complete record of what was said or what was disclosed at that time. I think we're making a distinction between having the court reporter there to preserve the record and create it versus ordering, a paper copy of the transcript. Right? I don't know if the language here allows for the consumer to just order willy-nilly every transcript that they want to run up the price, because there's a difference between transcribing it and then actually producing the record, although I would imagine they probably do it on disk now instead of on paper. So it's the goal here is to have that preserve what was actually said in that, and I agree with your observation that the 1 in the 1,000 arbitrations that are going to be challenged because of some misconduct. There has to be something else that was done in the during the proceeding that you can clearly show that the arbitrator was biased or a reason to overturn the decision. Do you have anything to add?
No, I don't think so. I mean, it's interesting, the concept of the court reporter demonstrating a bias on behalf or a preference within the context of the proceedings. If that's the case, I think it militates in favor of enabling people to bring their own, because obviously if it can happen on one side, it can happen on the other. And so, I think it would happen almost never, but in those cases, you may need to have a party be able to bring their own court reporter because they don't think that the proceedings are going to be fair. In depositions, you're right, there's already somebody there, but I think that probably would take care of the fact that somebody is transcribing it and is going to be paid for by the other party anyway, or in the proceedings. I think that will probably suffice. I can't imagine anybody wanting to bring a second court reporter to a deposition or to a proceeding unless they had a feeling that the other one, that the official court reporter was going to be doing it wrong.
But surely you can see the circumstance where you've got a requirement that the other side pay for the deposition, that somebody schedules depositions in these cases and just sticks the court reporter bill with the other side. I mean, that's going to happen. That's not fair. And currently, if you notice the deposition, you've got to pay for the transcript yourself. So you're switching the burden of paying in the deposition context. Forget that I think it's a bad idea in general, because all of these arbitration clauses have fee-shifting provisions at the end. Typically, the loser is going to pay, including the costs, and that would take care of the indigent problem in the arbitration itself. But in the deposition, suddenly I'm indigent, I'm up against it's a consumer arbitration. I can notice depositions and have the other side pay for them. That's a fundamental shift.
But in an arbitration right now, an indigent consumer could ask for a deposition anyway. What is it?
They have to pay for the transcript. You've shifted that and said that the business facing off against an indigent has to pay for that transcript.
So we're presuming that the company is not going to have a court reporter there at a deposition because they didn't ask for it.
They're not asking for the deposition. They've got no obligation because they're not asking for the deposition. The indigent asks for the deposition, and under your bill gets to stick the opponent with the transcription fee for the deposition. I understand you want to do that in the arbitration, and I think that's already covered by fee-shifting provisions. Right. You're now extending it to depositions where it's never gone before, and that's fundamentally unfair.
I thought the witness who came up is saying that he thought that it was a redundancy, that in depositions you were already going to have a court report.
You are. It's a question of who pays. You can't have a deposition without a court reporter. Normally, the party that notices the deposition has to pay. What this bill, I think, says is if I'm an indigent and I notice the deposition, I get to make the other side pay.
Right. Okay. I misheard what the witness said because I thought he was saying that the issue of paying is clear. He was saying that if there's a deposition, there has to be a court reporter there anyway. Right. So there's no reason for the language in the bill to say that you have a right to have a court reporter in the deposition because that's already sort of required here.
And I'm agreeing with him, and I'm saying if you don't take that language out, what you're going to find is a situation where there's already going to be a deposition with a court reporter. All you've managed to do is, in these indigent cases, shift who has to pay for that court reporter.
Well, once again, I find myself being a champion of the indigent.
There you go.
So I will have to leave the language in the bill as it is right now. But fair enough. Fair enough as a criticism. And with that, I'll take that as my close if there's no other questions.
Thank you. Other questions from the committee? We will take that as your close. We do have a motion and a second. It is due pass. Call the roll, please.
Stone?
Aye.
Stone, aye. Wagner? Wagner, no. Alejo? Alejo, aye. Chow? Chu? Gallagher? Garcia?
Okay. That's fair enough.
Garcia, aye. Holden? Mainshine? Mainshine, no. Ting.
That bill is on call. Now we have next item number 1, SB 316, Senator Mitchell.
Mr. Wachowski left his coffee cup.
Good morning.
You're right. What coffee? Your mom's not here, ma'am. Thank you, sir. I appreciate it. This is mine. That's right. I'll take mine on when I leave.
You can admonish Senator Wachowski for not cleaning up after himself.
Yes. Yes. Oh, it wasn't your coffee?
That was here.
That's mine.
Oh.